The Nkandla case of March 2016, it gave South Africans clarity about the powers of the public protector. You'll remember the Constitutional Court spelling out that the recommendations of this Chapter 9 institution were not merely recommendations, but also binding. So, here's the question. These powers, do they extend beyond binding? Here's the reason we are asking that question. On Tuesday, the lawyer for the suspended incumbent, Busisiwe Mkhwebane, introduced a clip of the Gauteng Judge President, Damson Mlambo, in which he had this to say about the powers of the public protector. Let's take a listen.
There is nothing in either the Public Protector Act or Ethics Act that prohibits the public protector from instructing another organ of state to conduct a further investigation. The Public Protector Act expressly empowers the public protector to obtain assistance in her investigations.
And let's introduce into this conversation now Advocate Paul Hoffman. He's a director at Accountability Now. Advocate Hoffman, thank you very much for your time. I hope you did hear that soundbite. Perhaps let's give the context. The context here is that Busisiwe Mkhwebane, in her investigative report into the CR17 matter, she, as part of her recommendations, appears to be instructing the National Prosecuting Authority to investigate the matter around these funds that were donated to Ramaphosa's ANC presidential campaign, because in her wording, this potentially had the hallmarks of money laundering. And so that's the context. What do you make of that statement now from the judge?
Yes, I think the judge has got it perfectly correct. It's one thing to refer a matter to a investigative body such as the Hawks, police, SIU, even to the revenue authorities. And it's quite another thing to order the National Director of Public Prosecutions to take action. And the way that the report was worded went way beyond the constitutional right of the public protector to take appropriate remedial action. I think the exact wording, yes, that is the exact wording, to take appropriate remedial action. In any matter referred to her office by way of a complaint of alleged irregularities in the conduct of state affairs or in the public administration. And you'll remember that this was fundraising going on in a private political party, not state affairs or the public administration. So the judge took a dim view of the public protector ordering Shamila Batoyi's troops into action by the way that she had worded her report. What she should have said was the matter reeks of money laundering. I would like the appropriate authorities in the Criminal Justice Administration to look into it and to see whether there has been any money laundering or not. It would have been on safe ground if she'd done that. But because of the way, the sort of high-handed way in which she purported to dish out instructions to the National Prosecuting Authority, which according to the Constitution as well, is meant to act without fear, favour or prejudice. She got up the nose of the judge and of the chief prosecutor all at the same time.
Advocate Hoffman, I don't know. Maybe it's possible that I may have missed it. You will remember very well that the office of Advocate Shamila Batoyi protested around this instruction, as you put it. I want us to take a listen to it again. The judge, if the team can just cue that bite once again, because I'm interested in the wording that Damson Mlambo uses. Let's listen to it again.
There is nothing in either the Public Protector Act or Ethics Act that prohibits the Public Protector from instructing another organ of state to conduct a further investigation. The Public Protector Act expressly empowers the Public Protector to obtain assistance in her investigations.
Advocate Hoffman, there's that word. It's instructing. Instructing is the operative word here. The judge says it. What's wrong with what Busisiwe Mngambi said then?
I think you must understand that in its proper context. He's not only talking about the constitutional powers which I have explained in relation to conduct in state affairs and in the public administration, which fundraising for a political candidate is not. He's talking about the Executive Ethics Act. Now, that act, rightly or wrongly, has made the Public Protector the policeman over the executive. So the powers of the Public Protector in relation to that act are not coextensive with the powers that derive from the Constitution and from the Public Protector Act, which basically puts flesh on the bones of what the Public Protector is allowed to do in terms of the Constitution, which is to investigate, report, and take appropriate remedial action when there are allegations of impropriety in the conduct of state affairs or in the public administration. So that's where I think you may be getting a little confused, and I think that the word instruct is different to the word order, and I think that if you have regard to the Nkandla judgment, which you mentioned in your intro, there the court found that the provision in the Constitution that says that the Public Protector is empowered to take appropriate remedial action means that that remedial action is binding unless it is set aside on review by the High Court. So the Public Protector enjoys a role in which her remedial action stands unless it is set aside
by a court of law.
That's what happened in that case.
You've explained this very well, Advocate Hoffman, and so it's important, therefore, that we also, I suppose, we become alert as this inquiry does lead to its conclusion, which I'm sure it is any time now after her testimony. How important is it for the public to educate themselves about these, the history of how Advocate Mngambi has conducted herself? Because the introduction of clips such as these, they could potentially have the power to confuse the public. And I'm saying this because immediately after that clip was played, you could hear the sound. In fact, even his name appeared on the screen, because this is also partly virtual. You could hear the leader of the UDM, Bantu Olomisa, exclaiming that our case up. In other words, there simply is no case here. In a way, almost inferring that the Public Protector may necessarily not have done anything wrong. How important is it that we will listen with a critical ear, but also perhaps just go back to the judgments and educate ourselves a little bit more?
Yes, no, it certainly is very important. It has always been the function of the Public Protector when, in the course of an investigation, possibility of criminality is raised, to refer the matter to the Criminal Justice Administration. The problem during the period of state capture, when Thuli Madonsela was still in the saddle, is that there tended to be some scope creep, if you like, because the Criminal Justice Administration descended into a state of dysfunctionality and certainly wasn't going to stick its head above the parapet in order to take pot shots at important politically connected people, whether inside or outside of Parliament or the executive. So that scope creep led to the point eventually where Xoli Mngambi said, I've got complaints about state capture. They're too big for me to handle. As my remedial action, I'm asking the Chief Justice to appoint a commissioner to run a commission of inquiry, which is why we had the Zondo Commission of Inquiry. People seem to think that the ANC can take credit for that. In fact, Xoli Mngambi must take credit for it. But as far as the public is concerned, I think it's important to understand that all of the 6 Chapter 9 institutions that were set up in our Constitution are there to support constitutional democracy. They are there to bed down the idea that the Constitution is supreme and the politicians cannot do as they please. The public service cannot do as it pleases. They must both paint with inside the lines drawn by the Constitution. And the idea of a public protector is to have a free service for ordinary citizens who feel that the public administration or the conduct of state affairs is being conducted irregularly and in a way that is prejudicial to them. And you get all sorts of Gogo Dlamini complaints about Home Affairs not handing out passports and travel documents and so on, right up to these big cases that involve state capture and Cyril Ramaphosa's campaign funds when he succeeded Jacob Zuma as leader of the ANC in a party political election, not in a national election. So the idea that the public should be able to trust the public protector to do her work properly is central to the success of a particular institution that has been set up in order to protect the public against malfeasance or even misfeasance in the affairs of state and in the public administration. Remember, a lot of the things that get to the public protector are not because of criminal activity, but because of lack of skill or incompetence or lack of knowledge of how to do the job on the part of the civil servant or political player who is involved in the conduct of state affairs or in the public administration. So that sort of complaint is what the Public Protector's Office is designed for. It is not designed to be a super criminal investigative body, nor is it designed to be a body that dishes out instructions in a binding way, orders the National Prosecuting Service to do work for it.
Advocate Paul Hoffman, thank you very much for the clarity on this matter.